Welcome. I'm going to just give you a broad idea of kind of what the project that two of the presenters are member of this project that I'm leading. It's called Belghis, Building Conceptual and Methodological Expertise for the Study of Gender, Agency, and Authority in Islam. So it's a 5-year project. We're actually through the first year of it. It's a European Research Council Consolidator grant, and we are based at the Irish Centre for Human Rights at the University of Galway. So Belghis basically investigates Muslim women's access to justice in Europe by studying how Muslim women in Europe have navigated questions of agency and authority from the 19th century to present day. So our first speaker, Dr. Nazife Kosukoglu, sorry Nazife for my pronunciation again, is a postdoctoral researcher in Ottoman history with the project. She's a wonderful colleague, and we miss you, Nazife. And so Nazife studied political science and international relations at the Marmara University. She continued her studies at Boğaziçi University and obtained an MA in modern Turkish history. In 2002, she received her PhD degree in the same field from Atatürk Institute of Boğaziçi University with her dissertation that focused on gender violence and criminal law in Turkey. She was the recipient of Shirin Tekli Research Encouragement Award and the Yeliz Dunmez Award for Best Dissertation. Her academic interests include gender, regimes, legal history, socio-legal studies, violence, and intimacy. So Nazife will speak first, but I'll introduce our next two speakers as well. And I'm just going to give you a little bit of an idea of the project because the broad title for the panel is something on fatwa, and actually the panel is not necessarily about fatwa. It's more about the women access to justice, legal pluralism. Joel is looking at the European Council of Fatwa and some other fatwa bodies, but very specifically to do with Islamic law. So Dr. Joel Hanisek will speak second. Joel is a research fellow at the Irish Centre for Human Rights, School of Law, University of Galway. Previously, he was policy and program manager for Scholars at Risk, where he managed the EU-funded Inspire Europe and Inspire Europe Plus projects and supported activities of Scholars at Risk sections across Europe. He has a background in NGO advocacy and United Nations Economic and Social Council, and was previously also a member of the New York-based NGO working on the Security Council. He holds a PhD from Trinity College Dublin and researched socio-religious aspects of memory and mobility in Iran-US transcultural context. And last but not least is our wonderful friend and colleague, Dr. Afrooz Maghzi. Afrooz was recently a research fellow with the program on Law and Society in the Muslim world at Harvard School of Law. She holds a PhD in law from the University of Halle, Wittenberg, and Max Planck Institute, Germany, with a focus on religious and customary-based non-state justice. Additionally, she has an LLM from University College Dublin, Ireland, and another LLM from Mazandaran University in Iran, and an LLB from Tehran University in Iran. Afrooz actually currently works with UN and EU human rights agencies as an external legal consultant, and she has worked as a lawyer, researcher, and activist in Iran, Ireland, and Malaysia, cooperating with several civil society and international NGOs. So really delighted to have these three wonderful speakers. Belghis the project is very lucky to have you all speak here today. Just very, very quickly to give you an overview of the project. As I said, it's a 5-year project, but 1 year is gone. It's Muslim women's access to justice. So we start with the historical, and this part is where Nazife comes in, and she's currently actually in Istanbul looking at the archival material of family courts, and you can ask her more about that after the presentation. And actually, so we are looking at, in that kind of period, at how Muslim women then, or women, because non-Muslim women also sometimes availed of these courts, negotiated these spaces, negotiated with the Ghazis, or with the muftis. Sometimes they actually got a fatwa to bring with them to support their cases in family law courts. And then we come into the more transitional periods. And this brings us to Greece, Bulgaria, and Bosnia. So we look at transition from the Ottoman Empire to modern, and again looking at how Muslim women negotiated certain spaces, different political transitions. From the Ottoman Empire to kind of different political authorities to communism, and then war, and then recently as well with transnational Islam, which Joel will be talking about. Because the role of transnational Islamic movements is really important right now, from Saudi Arabia to Turkey to other actors such as Iran. And then we come to Ireland, Sweden, and Norway, which is another part of the project. And this will look at kind of now modern time. So how do Muslim women living in these countries as minorities deal with access to justice? So again, how do they negotiate certain spaces? How do they negotiate their own agency with power and authority? So this could be the state. This could be, the mosques, for example, that they're going with the imams, or if within those states there are any religious authorities. Again, it's usually transnational religious authorities that we are talking about. And again, there are some European-specific ones which Joel will look at, and then the legal pluralism part, which is very important, which is Afrooz's forte. So with that, welcome, and Nazife, you have 15 minutes if you want to share your presentation.
Thank you very much, Roja. Hello, everyone. It's great to join you today. In this presentation, I will focus on late Ottoman law and judicial decision-making concerning honor killings, and explore Ottoman legal history with regards to this particular form of gender violence. Putting the cart before the horse, I want to talk about the main points that I will highlight. First, I will challenge the assumption that history was characterized by stability in this regard, because my examination will reveal the dynamism of late Ottoman legislation and case law on honor killings. Second, I will challenge the legalist tradition in Turkish studies. According to this narrative of legalist tradition, Ottoman Turkish history has been shaped by an all-powerful legislative and executive branch, and a judiciary that only applied the rules enacted by the former. In this understanding, judicial activism, especially progressive judicial activism, had no place in this legal tradition and emerged as a practice only in recent decades. In this presentation, I will challenge this narrative based on empirical research. The judicial activism that I examine in this paper was practiced by the Ottoman Court of Cassation, which was a secular institution. And it was triggered by the Ottoman Parliament, which tried to reintroduce impunity for honor killings. My final point is related to the sources and concepts the High Court judges used to practice such activism. I will show that these judges used concepts and interpretations stemming from Islamic law and Ottoman legal tradition to resist impunity and to continue punishing the perpetrators of honor killings. Thus, this paper also shows that interactions between secular law, religious law, and legal tradition may produce diverse and sometimes unexpected outcomes for the protection of women's rights. So, before going into the details of this judicial activism issue, I want to elaborate on the norms and rules about honor killings in the Ottoman Empire. In the Ottoman Empire before the 19th century, there was an exceptional accommodation rule for honor killings. And this was similar to British and French regimes, which also had special provisions for this sort of crimes. If a man who found his wife committing adultery killed her and her sexual partner, he would be free from punishment. Thus, the Ottoman regime provided impunity for such crimes. The scope of this extraordinary mitigation rule was limited in the 19th century. In the new criminal code adopted in 1858, there was an article concerning such crimes. This article stipulated that the sentences of such criminals would be reduced in a great extent. Thus, impunity was replaced by sentence reduction. The punishments would be softened to some degree, but there would be some punishment in the end. It's important to note that even in the period before the 19th century, there were norms and rules which limited the application of this extraordinary mitigation norm. Most of these limitative norms were related to the notion of şüphe or doubt, and Islamic legal interpretations concerning zina, that is adultery. Due to this complex notion of doubt, sentencing a person for adultery was extremely difficult because there had to be 4 adult witnesses who saw coitus with their own eyes. Otherwise, the claim that the couple committed adultery would be doubted. This concern with eliminating doubt was highlighted in various fiqh books and became an important element of Ottoman legal tradition concerning the prosecution of adultery. The limitative norms concerning honor killings were linked to this larger or broader legal tradition. One of these limitative norms concerning honor killings was the 2-victim requirement. In order to benefit from extraordinary mitigation, one had to commit double murder. He had to kill both his wife and her paramour. If he killed only one of them, he couldn't benefit from this special provision. This requirement was also related to the notion of şüphe or doubt. According to Ottoman jurists, if one killed only one person and wanted to benefit from this provision, his intent would always be doubted. Second, there was the character requirement. Ottomans doubted the integrity of men who raised such claims. They examined the character of the man and the nature of his relationship with his wife. According to some very authoritative fatwas, a man could only benefit from this provision if he was known as an honest person who was not abusive towards his wife. Finally, in the most authoritative fatwa collections compiling fatwas of Ottoman Sheikhul Islams, there was a direct witnessing requirement. Unless one directly witnessed some sort of physical interaction behind closed doors or in a bed, he couldn't benefit from this norm. For example, unless they were lying in a bed, a chat between a man and a woman was not accepted as a sign of adultery. If a husband found his wife in such a situation and killed her, he couldn't benefit from this mitigation. After this examination of the legal and normative framework, I want to dive into the amendment process that triggered the practice of judicial activism. In 1911, the Ottoman Criminal Code was amended in a significant manner. In this process, the article that provided extraordinary mitigation was also changed. The change of this article took place after long deliberations and was supported by lawmakers from various backgrounds. According to the group which proposed the amendment, the Sharia gave husbands the right to kill such wives. Thus, punishing such husbands was against the requirements of Sharia. However, impunity for such honor killers was not only supported by conservatives. Some liberal lawmakers supported the proposal for the extension of this mitigation, with references to the freedom of will and its lack upon witnessing adultery. Despite some opposition underlining the fact that there were no stipulations about this in religious law, the article was amended in a way to reintroduce total impunity for such murders. What is most interesting is what happened after this amendment. Despite the initiative of lawmakers to reintroduce impunity for honor killings, the law in action didn't transform in this direction in practice. Due to the judicial activism of judges at the Ottoman Court of Cassation, this initiative didn't produce the desired outcome. Drawing on established norms in the Ottoman interpretation of Islamic law and legal tradition, High Court judges rendered the application of this extraordinary mitigation article practically impossible. In fact, they didn't approve a single case in which this article was applied. In one of these cases, and this case is from Thessaloniki or Selanik, Dimitri, a Greek man, had killed another man named Nicola Atnas, who had a relationship with his mother. In the decision, it was underlined that there were rumors that Dimitri's mother and Nicola had an affair. On the day of the murder, Nicola had found Dimitri around his mother's house. When Dimitri found him, his mother was not around, but Nicola's pants were untied, which could be interpreted as a sign of sexual relations. The local court applied the extraordinary mitigation article, but the prosecutor at the Selanik court didn't agree that this murder was committed upon adultery. The Court of Cassation agreed with the prosecutor, highlighting that Nicola was found around the house and not inside it. Moreover, the judges underlined that rumors would not suffice to legitimize reducing the sentence on the basis of the extraordinary mitigation articles. Dimitri had not directly witnessed an interaction, a physical interaction between Nicola and his mother, and thus couldn't benefit from this article. In a similar case, a woman named Leyla was killed by a group led by her husband Hafir. On the night of the crime, Leyla was traveling in a carriage with non-mahram men, that is, men who were not her relatives. According to the decision, Leyla was known to prostitute herself, and that was why she was in the same carriage with this man. While they were on their way, a group of men, led by Hafir, stopped the carriage and severely wounded Leyla, and she later died because of her injuries. At the Court of Cassation, the extraordinary mitigation couldn't be applied in the case, because even if Leyla was a woman of loose morals, and even if she was found with other men, the attackers had not found them in a home or bed, or witnessed some sort of physical interaction. Thus, the direct witnessing requirement was not fulfilled. Again, the Ottoman legal tradition linked to doubt and direct witnessing were evoked to stand against impunity for honor killings. In another case, a woman named Ayşe was killed by a group led by her brother Ahmet. Some time ago, Ayşe was divorced by her husband because she cheated on him with someone named Durmuş, and this was established as a fact. After the divorce, she started to live in her own home, and Durmuş was known to visit her from time to time. And the attackers had attacked Ayşe's house during one of these visits. Thus, the two were found in the same home. However, the Court of Cassation decided that the direct witnessing requirement was not fulfilled because the attackers had not seen any interaction between them with their own eyes. And the autopsy report stated that Ayşe's body was fully clotted when she was found. Again, the High Court had blocked the granting of impunity in a case of honor killing. As seen in these cases, in the 1910s, there was an extraordinary mitigation article on paper, but in practice, its implementation was extremely difficult, if not impossible. The Ottoman Court of Cassation demonstrated a considerable degree of judicial activism in this regard and developed a very narrow interpretation of the extraordinary mitigation article. In doing so, the High Court judges stopped the initiative of lawmakers to expand the legal accommodation provided for honor killings by drawing on the notion of şüphe or doubt and legal norms that were developed on this basis. And this brings me to my conclusion. As shown in this presentation, late Ottoman history concerning honor killings didn't follow a linear path. There were, in fact, fluctuations. Thus, the findings of my research challenge the assumption that history was characterized by stability in this regard. As I highlighted, there was also a considerable difference between institutional responses to honor killings. While the majority at the parliament wanted to extend the legal accommodation provided for honor killings by reinstating exemption from punishment, High Court judges were against such initiatives and insisted on limiting this accommodation. This points out to the heterogeneous character of the late Ottoman state and serves as a reminder that Ottoman state elite was not a unified entity. Finally, as shown in this examination, Ottoman judges at the Court of Cassation practiced a considerable form of judicial activism to stand against the legislative initiative to provide impunity for these crimes. They utilized various concepts and interpretations stemming from the Ottoman interpretation of Islamic law and legal tradition to prevent impunity. This shows that interactions between secular law, religious law, and legal tradition may produce diverse and sometimes unexpected outcomes for the protection of women's rights. With this, I conclude my presentation. Thank you very much for your time.
Thank you so much, Nazife, for a really wonderful presentation. We'll come back. I'm sure there's some questions for you. So we'll come back after the presentations and take questions and have discussions. So invite Joel to make his presentation.
Good to see you all. You'll note that the presentations have a wide scope in terms of their history and focus. So this presentation will invite some consideration on the social, legal, and political dynamics that are related to collective ijtihad, and specifically is going to look at the work of the European Council on Fatwa and Research, which is a transnational collective fatwa body. Significant work on the European Council on Fatwa and Research, I'll call it the ECFR, has already been undertaken by Alexander Cairo, particularly as the Council relates to transnational ulama, Islamic authority, and European fatwas. And this paper acknowledges Cairo's influence on this vein of thought. So I just wanted to reference Cairo's work as a background for the paper. The ECFR as a body receives questions primarily from Muslims living in Europe, and at times from Muslim organizations that are dealing with a variety of social issues. The average number of queries they receive is around 25 per day. And I think it's important to underline that only a small part of the fatwas that the ECFR receives are actually published. So it's receiving a lot more than it's actually publishing publicly. In this context, the question of the Council's impact or influence is an important one, and that's a dominant preoccupation of this paper. Because while the ECFR aims to become the primary religio-juristic authority for European Muslims, the relevance of the Council to contemporary practices of Islam, particularly in Europe, is simply not clear at this point in time. One case study that we have, which focused on mosques in Dortmund, Germany, was done by Uriva Shavit and Fabian Spingler, and they conclude the following. Basically, the data that they collected suggests that the imams at mosques that they studied did not consult the European Council for Fatwa and Research judgments, let alone privilege their decisions, whether that be in their print or online versions. They simply weren't readily available to the mosques, either leadership or attendees. And in fact, a majority of the attendees were not familiar with the existence of the ECFR, including hallmark decisions. So one of those decisions would be the permissibility of mortgages. And the Council's stance on mortgages, which legitimize the practice of home mortgage lending for Muslims in Europe, is simply an illustration of the way that these fatwas really bring together the intersection of theory and practice in Islamic law. However, in this case, it appears really that the theoretical framework of the ECFR was just unknown or undervalued amongst the Muslim communities in Dortmund. So reaching significant or broader conclusions about this lack of familiarity is really going to be impossible at this point, absent additional case studies in other country contexts. But the implications of collective fatwas for women in particular is a topic that Lena Larson addresses in her scholarship, specifically in relation to the ECFR. And Larson observes the following via first-person conversations that she's had with members of the council. She notes that women-related fatwas do make up a considerable percentage of the total number of fatwas and resolutions that are published by the council. And there are two reasons. One is that women make up a far larger share of those contacting the council. And the second is that women-related topics are considered by council members as being the most important topics, particularly in relation to questions of Islamic identity broadly construed. Thus, without making an evaluative judgment with regard to the council's methodology or outcomes, we can still recognize the broad normative importance that a European deliberative fatwa body might have for Muslim women in Europe. And Cairo also affirms this, noting that family issues, especially marriage and divorce, arguably absorb most of the time of the imams officiating in mosques across Europe. Okay, so historically, individuals seeking fatwas delivered their question, the answer was returned in written form on paper, and collections from major jurists were collected and published as books. The ECFR has also issued the outcomes of its ordinary sessions in printed and electronic forms. However, the website is simply not updated regularly, so that's another difficulty in terms of doing at least online research with regard to the ECFR. Working now from the basic understanding of fatwa as legal opinion given by a qualified jurist in answer to a question that can be delivered in written or oral form with certain requirements, conditions, and surrounding the process, it's important to consider how new and emerging collective aspects of fatwa giving, such as the ECFR process, may affect the evolving relationship between local Islamic discourses, such as the one that Chavez and Spengler were looking at in Dortmund, and transnational ones. The ECFR process often involves questions deemed relevant to Muslim communities in Europe being distributed in advance to members of the all-male ECFR Council. Each council member then presents their own answers, and those answers are in turn considered collectively. After comments, proposed changes have been received, in some cases there's a consensus response that's reached, and in some cases a majority view is presented as the response with dissenting positions among the council noted. This differs, of course, from the fatwa process within Shi'ism, where there is also an additional positive obligation to follow a fatwa given by one's chosen marja taqlid. And a Shia Muslim living in Europe and inclined to seek such a response would, of course, call the offices of their chosen marja or use the website to submit a question. And I think I'm making this distinction only because it's important to remember that there's only 54 Shia clerics who currently hold the status of marja taqlid globally. So there's a sort of a resource scarcity question in this regard as well. The ECFR process is also different, again, from other contemporary innovations within fatwa culture, particularly that of the fatwa call center. These call centers differ in kind from each other. Some are state-backed, for instance, in Turkey, where the Diyanet administers a fatwa hotline staffed by state-sponsored muftis, both male and female. Therefore, the question of women's access may also be profitably raised for the ECFR, particularly including with regard to a lack of women's formal representation on the council. In another instance, Cairo and Mahmoud al-Safi have found that Allo Fatwa, which was a short-lived payphone line established in France in the early 2000s, actively sought the advice of the ECFR in order to resource questions, and it even displayed the names of members of the council as sponsors of the initiative. In that case, Yusuf al-Qaradawi, the founding chair of the ECFR, was at the top of the list. Qaradawi, with his links to the Muslim Brotherhood, may be seen as both an organizing and a divisive figure for the ECFR. The question of Qaradawi's foundational leadership and its influence on the international, the theological, and the financial aspects of the ECFR is also deserving of further research. As Cairo notes, the ECFR remains exclusively male and Sunni, overwhelmingly Arab in ethnicity, and close to what he terms the middle ground ethos of Qaradawi and the Muslim Brotherhood. So as we continue to gather more information about how women approaching the ECFR with questions related to access to justice have been facilitated or frustrated, we can also begin to analyze the degree to which their success or failure has depended upon whether the ECFR was understood to constitute valid religious authority and how its relationship to religio-legal practices and policies in states outside of Europe has been structured. We know that contemporary fatwas, and particularly the questions they respond to, give us valuable insights into the gendered relations guiding European Muslim communities. We do not yet know what innovations such as collective consideration employed by the ECFR in fatwa production might mean for Muslim women's access to justice in Europe. And it's important to recognize that these are long-standing concerns, of course. It's been 20 years since Adela Abu Sharaf asserted that research on gender justice should examine the struggle of women against powerful variables such as strict fatwa, different legal settings established by the discourse of religious institutions, and the possibilities for women to negotiate their roles and their rights. In that respect, regional research projects such as Bilqis that investigate the socio-legal status of Muslim women promise opportunities for comparative analysis and modules for planning how better to approach socio-legal studies in any specific community or country. Yet questions of access to justice for Muslim women in Europe remain frustrated by a deficit of attention to women's agency and women's authority, both in the context of Islam as a socio-cultural influence, as well as in rights-based legal analysis of European laws and policies. In part, I'd like to suggest that this could be remedied by approaches that do the following. One is moving away from locating solutions entirely in legal pluralism debates that are grounded by a male-dominated understanding of practices of Islam. The second is recovering traditional modes of Islamic cultural practices that invite possibilities for women muftis. And the third is to emphasize the non-binding aspects of transnational collective fatwa bodies and to encourage them to be viewed and engaged with in cultural rather than strictly legal terms. The presence of women muftis on collaborative international fatwa bodies, such as the European Council for Fatwa and Research, could therefore be advanced in line with historic descriptions of formal requirements for muftis across various mazahib. Jacob Skovgaard-Peterson notes, for instance, that, of course, a woman may act as a mufti. The stipulation is the requirement of knowledge and ability to communicate. He continues, muftis are known and respected for their scholarly insights, and some of the treaties divide the muftis into classes according to their competencies, with the highest class capable of making altogether new legal rulings based on an original assessment of the Quran and Sunnah. Thus, we could anticipate, and I say this in conclusion, we could anticipate the presence of women muftis on transnational collective fatwa bodies with a regional focus, such as the ECFR, as being advantageous to legal rulings requiring special competencies, particularly in gendered forms of knowledge, that address both the women-related fatwas engaged by the Council, as well as the experiences of Muslim women who make the largest share of those who are actually seeking the fatwas. However, if the influence of the ECFR as a collaborative body is already weak in Europe, then a push for such deliberative inclusion may not be the most strategic path towards advancing gender justice, and particularly Muslim women's access to justice in Europe. Similarly, in the case of the ECFR, where the influence of Qaradawi and as well links to the Muslim Brotherhood have been observed, there are additional questions related to national state frameworks and also the navigation of socio-religious gender dynamics in an international context. These would, of course, also benefit from more scholarship than has been done, but could draw on that which already relates to the inclusion of women and gender reform within contemporary Islamic social movements. And I'll conclude there.
Thank you very much, Joe. And you gave us a lot of food for thought, so we'll come back again during the discussions. I have some questions as well. So Afrooz, please.
Hello, everyone. Thank you so much for being here, first of all. It's really amazing to be here and talking about my subject with Iranian audience and also people who are interested in Iran. And we have this very unique opportunity because of Iran Academia that I'm very, very much thankful. So I want to actually come from Europe and the context of Turkey to Iran. And what does it mean in Iran having different set of legal systems? My topic today is about the impact of legal pluralism on the personal status of women from religious minorities in Iran. Let me begin with an anecdote that sparked my interest in this subject. Back in 2008, I attended a conference on women's rights held by UNESCO in Qesh for local state officials. Qesh is an island, for those who don't know that. Qesh is an island in south of Iran where the majority of the population practices Sunni Islam. At the time, I was involved in the campaign of 1 million signatures, and my talk focused on the rights of girls under 18, highlighting the legal deficits in supporting women's rights. Not surprisingly, my presentation was met with heated discussion and reaction from the attendees, who found the idea of rights of girls under 18 to be contrary to Islamic laws and their traditions. After the conference, one of the kind local women who had helped organizing this conference approached me. She said, "You know, what you explained about the terrible situation of women and girls under Iranian law is true, but I wish we had even that much. After my father passed away, all the money went to my oldest brother based on our religious rules. At least under the general state law, women inherit something." That was a huge shock for me. Not because I was unaware of the religious minorities in Iran's situation and the fact that they are governed by their own religious laws in the personal status matters like divorce, marriage, and inheritance, but because it was the first time that the reality of such laws hit me. We had studied this clause in Iran's constitution as a progressive measure respecting religious minorities by allowing them to follow their own laws regarding personal status. However, encountering this woman's story made me realize the profound and often negative impact that this so-called respect for religious minorities clause in the Constitution has on women's rights within some religious minorities in Iran. Legal pluralism refers to coexistence of multiplicity of legal systems within a single geographical area or society. It occurs when different groups within a society are governed by distinct sets of laws, often based on religion, ethnicity, or other social divisions. The concept has historical roots, becoming more widespread during colonial times when European powers imposed their legal system while allowing indigenous or religious laws to persist for local populations. In modern time, legal pluralism is evident in countries where religious or customary laws operate alongside civil laws, particularly in areas like marriage, divorce, and inheritance. While legal pluralism is often seen as a way to respect cultural diversity and protect the autonomy of indigenous people, it has become increasingly controversial, especially over the last 20 years in the Western countries like Europe. This is due to conflicts that arise from differing standards of rights and justice, when particularly impacts vulnerable members of the group, especially women, LGBTQ+ individuals, and children. In Iran, we see the reflection of this multiplicity of legal systems in recognition and application of different laws for various official religious minorities. The complexities of this matter, however, must be understood in the context of the situation of religious minorities in Iran. While religious minorities experience a relatively tolerant society under the secular Pahlavi dynasty, their situation changed profoundly after the 1979 revolution. The Iranian constitutional law considered the 12-hour Jafari school of Shia Islam as the state religion. Article 4 of the Constitution establishes the absolute supremacy of Islamic law, stating that all laws and regulations must comply with Islamic principles. The Constitution's approach toward religious minorities can be classified in two categories. The first include the officially recognized religious minorities, which consist of non-Shia Muslims such as Shafi'i and Hanafi Sunnis, as well as non-Muslim religions like Zoroastrians, Jews, and Christians. These groups are the only recognized religious minorities in Iran. By this definition, other religious minorities, particularly the Baha'is, are not recognized as a religion and have faced persecution for years because of their beliefs. Even the officially recognized religious minorities, especially non-Muslims, are deprived of full citizenship rights. They are restricted from holding position of power in political and judicial system and do not receive the same protection under criminal and civil law. Despite this restriction, the recognized religious minorities are entitled to perform their own religious practices, educate their children according to their religion, and follow their own personal legal status. There is also a specific allocation for their representative in the parliament. However, it is also stated in the law that the ability of the exercise of these rights is reserved for those who have not conspired against Islamic Republic of Iran, and their action must comply with public order and morality. Interestingly, while the right of recognized religious minorities in many political, civil, and economic areas are subject to legal and de facto restrictions, they have significant authority over personal status matters. Under the law, matters related to divorce, marriage, and custody are determined based on the religion of the husband, while inheritance matters are based on the religion of the deceased. It is also important to note that members of religious minorities are required to follow their own religious personal laws and are not permitted to follow the general personal law applicable to the population of Shia Muslims. Prior to Family Protection Act of 2013, the court reviewed matters of personal status for religious minorities on a case-by-case basis, relying on the specific personal status laws of the applicant. However, in 2023, the law introduced a new procedure granting autonomy to the highest authorities of these minority communities to conduct investigations and issue judgments. As a result, the state court's role in Iran is now limited to upholding and enforcing the decisions made by these minority authorities without further processing. To understand the situation of women under these regulations, I will provide some examples of the status of women in relation to marriage, divorce, and inheritance laws among religious minorities of Sunni Islam, Christians, Zoroastrians, and Jews. These examples show the significant differences between these groups, which can sometimes be beneficial and other times detrimental to women's situation. However, research in this area is very complicated because while Zoroastrians and some Christian denominations have their official written regulations, other groups such as Jewish and Sunni associations have not submitted written regulations. Instead, they have requested that the judiciary consider the legal opinions on personal status in individual cases brought before the courts. One of the key areas I divergence is the minimum age of marriage. Under the Iranian law, the minimum age for marriage is 13 for girls and 15 years old for boys. In contrast, Protestant regulations set a minimum age of 18 years old for girls and 20 years for boys. However, in Sunni communities, the age of puberty is considered the minimum age for marriage, and the exact age is not specified. While the state law and all religious minorities require the willing consent of both girls and boys for marriage, some also require the permission of the guardian. For instance, the state family law and also Protestant regulations in Iran require that virgin girl require her guardian's permission, who must be her father or grandfather, for marriage despite of her age. In Orthodox Christianity, this permission is required for both girls and boys at any age, while in Zoroastrianism, permission is needed if they wish to marry before the age of 21. On the other hand, Armenian Gregory and the Hanafi school of Islam do not require such permission. Polygamy is another area where significant differences exist. According to state family law and other Muslim branches such as Hanafi and Shafi'i, men are allowed to have up to 4 permanent marriages simultaneously. However, polygamy is strictly prohibited among all non-Muslim religious minorities. Similarly, while temporary marriage is permitted under general personal law, it is prohibited in other Muslim and non-Muslim religions. Divorce also is one of the most controversial areas of family law in Iran. Under the state family law, a husband has a unilateral right to divorce his wife, while a wife can only apply for divorce if she can provide some very strict evidence that her marriage is unbearable. This is also the case for Sunni Muslims of Hanafi and Shafi'i school, in these two also Sunni schools of Islam. In different Christian domination and also for Zoroastrians, divorce is even more difficult and complicated, but the conditions for men and women are generally the same. Inheritance law is another significant area of inequality under Iranian law. For example, under the state family law, sons are entitled to twice as much inheritance as daughters. When a husband dies, if he has at least one child, his wife may only inherit 1/8 of the assets, whereas the husband's share from his deceased wife is 1/4 of the assets. However, the state family law is actually more favorable to women compared to Jewish and Sunni inheritance laws, where daughters and wives may not receive any inheritance. In contrast, Christian denominations and Zoroastrian regulations grant women the same inheritance rights as men. To conclude this presentation, I want to emphasize that my presentation today is mainly a call to listen to the unheard voices of women from religious minorities in Iran. Their experiences are severely overlooked in the broader discourse on women's rights in Iran, and the structural role of state law continues to perpetuate their subordination within some of these communities. From the initial research, we can highlight several important points in this regard. First, the legal pluralism practice in Iran represents the strongest one, characterized by no state supervision in ensuring the rights of vulnerable members of these communities. This lack of oversight allows the continuation of practices that undermine the basic rights of women, leaving them at the mercy of their community's religious law and leaders, often without access to any state protection. Second, while some non-Muslim personal status laws in Iran offer certain benefits to women compared to the state law, they all contain significant elements of discrimination against women. This includes gendered labor division and restriction of women for marriage. Third, despite the profound impact of this regulation on women, this area remains critically under research in human rights scholarship and is not mentioned in UN reviews concerning the situation of women in Iran. The amendment of the Family Protection Law in 2013, which granted minority religious authorities more judicial autonomy, highlighted this issue. In addition to substantive law, the procedural law within these communities may vary significantly. Some may adhere to due process principles, while others may apply more severe situation. And finally, the selective approach towards religious and conventional groups, the lack of choice for members of recognized minority groups over their personal status, and the neutrality regarding discrimination against women are in direct contradiction to the basic standards recognized under international law regarding legal pluralism. Thank you so much for listening, and I hope this discussion sparked some question in your mind regarding the situation of women in religious minorities in Iran. Thank you so much.
Thank you so much, Afrooz, for really thought-provoking presentation. So we have about 15 minutes left for questions and discussion. But before opening up to the audience, I liked how the presentations link in sense that as I said, the project itself on Muslim women's access to justice in Europe, and we are looking at minorities. So Muslims are minorities within European context, whereas Afrooz is looking at religious minorities within the Iranian context. And these whole questions of legal pluralism is actually central to our project as well. And you made me think a lot. And the other thing that links the three presentations together is around authority. So whether that be the states or religious authority, I think religious authority is actually, again, one common denominator. And with that said, Nazife, you spoke about the court of cessation, if I just look at my notes here, and the Ottoman court of, cassation, and the interpretation that they had of honor killing. Could you tell us a little bit about how that interpretation came to be, who was involved? Because you talked about judicial interpretation and judicial authority. So are you talking about the Ghazis at the time? Could you tell us a little bit about it?
The Ottoman Court of Cassation was a modern institution. It was established in the mid-19th century as a part of Tanzimat reforms, and its main objective was reviewing the cases decided by local courts. And it was a secular institution, and it was authorized to implement the secular codes, actually. But in this particular instance of judicial activism, we see that they draw a lot on this Islamic law and Ottoman interpretation of Sharia and Ottoman legal tradition, which was not officially within the secular corpus. And in terms of the people who took these decisions, we do not know much about them, because in the Turkish historiographical tradition, the judiciary is not considered as a very powerful branch. They are accepted to implement the decisions and rules enacted by the legislative and executive branches. They are just mostly seen as automats, really. So there is also not much work on them, on the judges' for example. And what we have is very limited compared to, let's say, American legal history. But still, we know that some of these people were educated in Islamic law. Some of them were educated in secular law, and that they combined these forms of expertise and knowledge when deciding about these cases.
Thank you so much, Nazife, for a really comprehensive response. I'll open it up to the audience.
For Nazife, I have a question. I am not sure if it falls under the scope of your speech or not, but I am so interested in knowing the current status of honor killing in local laws in Turkey.
It is criminalized, of course, but in fact, there is a specific article that provides sentence reductions for honor killings, and this is called unjust provocation article, haksız tahrik. And on this basis, these killers can be granted a sentence reduction by 3/4 of the original punishment. This is a lot, actually. And courts grant sentence reductions on various bases, judging the honesty of women, judging their honor, not the culpability of men. So this is still a very, very important problem in the Turkish legal field.
From Jul. I'm not sure, again, if it falls under the scope of your speech or not, but it was so interesting that, the main topic was so interesting to me. So how do international arbitration councils navigate the balance between upholding universal legal standards on one hand and respecting the socio-religious authority that often influences the communities they serve? So how they can make this balance in practice?
This is one where I think Afrooz possibly will have a stronger response from a theoretical perspective. My suggestion within the European context and the European Council on Fatwa and Research was simply to draw attention to the existence of this body as a collective decision-making body, which has the possibility to reform how we think about these processes, particularly including the voices of women more structurally. But in that regard, it's privileging that body as a soft cultural influence. So it's not in the same category of that strong legal pluralism that Afrooz was describing, I think, within the Iranian state context. This is thinking about a softer cultural influence that helps to navigate some of the community-based aspects that may be important for particular local forms and practices, and to do that with a broader conception of gender justice than is currently being conceived of or possible, based largely upon the composition of these decision-making bodies. The question, of course, was whether these bodies like the ECFR have any authority at all in that regard. And the one case study that I mentioned suggests that they're not really being listened to. So that was the sort of question I was throwing open. Strategically, do you try to engage with them, or is there a different way to proceed?
I see. Thank you so much.
And just before passing to Afrooz as well, I suppose what Joel covered with the European Council of Fatwa is very different to the arbitration councils, which Afrooz is absolutely the authority on. You've written.
No, just I want to say that I think that your answer was complete. I don't have anything to add. We have different kind of legal pluralism. Something that we see in Iran is a strong legal pluralism. But in the Europe, actually, there is no consideration of this kind of religious personal status. But they have an official impact on the decision in the judiciary and actually how the for example, the conflict in family situation in this kind of family conflicts can be settled. That's why, I think.
Yes, thank you for clarification.
Yeah, it's two different kind of legal pluralism.
And one more question for Afrooz, if it is possible, to context Iran. قطعا میدونم که تمام نکته هایی که گفتی توی religious minorities برای وضعیت حقوقی زنان در ایران، میخوام ببینم که بعد از همه تحقیقات و مطالعاتی که داشتی چه پیشنهادی، به قول معروف اون دنبال اون جواب so what، یعنی چه کار میشه که تو همین کاندیشنی که الان ایران داره، یعنی قبل از هر چنجی، آیا مثلا فکر میکنی که بشه با لوکال، یعنی با توجه به اینکه اگه ما وضعیت جغرافیایی religious minority ها رو ببینیم یا اصلا به وضعیت جغرافیایی کاری نداشته باشیم، آیا فکر میکنی که بشه مثلا با لوکال اتوریتی ها صحبت کرد برای پالیسی چنج های خیلی کوچک، قدم های خیلی کوچک، بدون اینکه حالا دست به تغییر قانون تو اشل بزرگتر زد؟ یعنی میخوام ببینم که ساجستشن چیه اگر قرار باشه کار عملی انجام بشه.
Should I ask about the suggestion? Actually, legal pluralism was my topic during my PhD. And while Iranians have a very strong reaction to this concept, we have to say that it's the reality of all societies in the world. Legal pluralism is the reality. Okay, we cannot ignore it. We cannot actually completely put an end on that. But something that we can do, we shouldn't compromise the rights of vulnerable members of communities because of legal pluralism. No, we shouldn't compromise their rights. We have to see some, for example, we have to, and it is not suggestion, it is not, for example, something soft. We have to have very strong regulations that supervise all of this kind of unofficial procedure, or in some countries like Malaysia, official procedure, and see that whether the rights of minority in minorities, meaning women, children, LGBTQ people, actually whether the right of them actually is being respected or not. And they need, for example, in Europe, it's a very, it's a very important discussion, because at the moment they have a lot of immigrant communities, and they have their own law and the way of settling the problems. And there are different suggestions in Canada, in the US, the countries they are coming, in Europe, that is that before actually letting women, or for example people going to this kind of council, they have to have very good information about this procedure. They have to know their rights. And there are this kind of, for example, council, or, anyway, different places, different centers involved in this matter. They have to give enough information to them. That is not the state law. They are allowed to go to the state law. And the decision of this also organization are not enforced on these people. There are very different suggestions we can discuss.
So you mean more raise awareness and
what I want to say. There are, public awareness, everything, but we need to have very strong regulation to supervise this process and see whether the rights of women actually are respected or not. Not women, for example, women is my subject, children, other minority groups.
Yeah, I also think it's very interesting that there is no focus on it so far. So I was wondering, and maybe it's a intertwined question, if this is already acknowledged by the European, because you worked with or in the European Council. So if this aspect is already acknowledged in the European sphere or mentioned somewhere.
I think it goes back to Afrooz's point on regulation. The regulation, I would just affirm the importance of strong regulatory frameworks. Certainly women's rights are protected deeply and broadly within the European context. But I think there are instances where you have bodies like the European Council on Fatwa and Research, which are operating in somewhat parallel form. There's not a binding legal aspect within a European framework, but they do have power and authority that's afforded to them by a community context. And that community context may have some form of a gendered framework which is breaking against justice for women. So part of it would be thinking about how do you regulate these kind of bodies within Europe, including the transnational influences that I indicated, and part of that may be financial regulatory frameworks in terms of funding mechanisms. So from a European context, that's how I might think about answering it. Within a UN context, Afrooz, I don't know if you wanted to say something more about the review mechanisms within the UN in terms of rights of religious minority women within Iran.
regarding Iran, I told you, yes, there is nothing at the moment. But, there are very strong actual recommendations by different UN committees and commissions on how to deal with legal pluralism in a way to, protect the rights of minority in my. For that, there are very good standards, and, there are established standards in this regard, but there's nothing that was significant regarding the situation of minority women in Iran. And as I told you, because they never raised it. They never had a voice, actually.
Thank you again, everyone. Just to add to Afrooz and Joel as well. So one of the things with the projects that we are working on is, what should the relationship of the state be with these arbitration councils, for example? Because there is, you have to take into account minority rights. This is within the European context, but also Afrooz pointed to it in her presentation that the state basically gives the right to these minority communities, especially when it comes to personal status codes. And you mentioned, this is actually a colonial legacy in some ways, that the family law part, which discriminate against women, has remained intact both for Muslims within Muslim majority countries and minority populations within Muslim majority context, and then you're looking at Muslims as minorities within Europe, which, it's quite complicated. And there is no right or wrong answers to it. And even when Joel mentioned, are we talking about looking at women as religious authorities within these discourses? Does that even make a difference? Because if you're looking at these institutions, especially religious institutions that have discriminated against women, then where do women as muftis fit? And if you look at religious authorities, women religious authorities across the Muslim world, for example, either it's been very anecdotal or the ones that have been sponsored by the state. And Joel mentioned this in terms of the DNet in Turkey. It has been quite, it's not necessarily in favor of women because it's within an institution that could be discriminatory against women. But sorry, I sidelined a bit, but just to say that there's so many different pieces and it's so broad and complex. And at least this project, Belkis, gives us the chance to look at it from many different directions. And one thing that we weren't looking at is minorities within Muslim majority countries, but Afrooz's presentation really gave us a lot of fruit for thought and all the presentations. So thank you so much, Nazife, Joel, and Afrooz.